All right, good morning, everyone. I'm just going to make sure that I get the thumbs up from our moderator, Mr. Clark, that everyone can see and hear me. Yep, perfect. Good morning, everyone. Welcome to another Aitken Partners breakfast briefing. My name is Paolo Tatti. I'm a managing principal with Aitken Partners, mainly in the insolvency and litigation team. This breakfast briefing is titled, "Is the Family Home at Risk?" What makes this briefing so interesting this morning is that we get to explore the interaction between two competing and mutually exclusive presumptions that we'll go through in a moment. The presumption of the resulting trust and the presumption of advancement, and how that interplays with at least four seemingly different areas of law: commercial, insolvency, family, and succession law. The catalyst for this morning's talk was a recent decision from the Federal Court of Australia, where three judges decided a case. Our first speaker, Tom Carroll, is going to tell you a little bit more about the facts and how they're fairly unique in many ways. But from your perspectives, this case in particular has serious implications for professionals, business people, and perhaps just everyday people who have arranged their affairs in a particular way. So before we get to all of that, I thought I'd just spend a moment just reminding people, or perhaps if you haven't heard about these presumptions before, just briefly explaining what they are. The first is the presumption of a resulting trust. The easiest way to explain how this arises is where two parties buy a property together. They both contribute to the purchase price, but the property is only registered in one person's name. Equity will presume that even though one person has that legal title, both parties will own that property beneficially. The second presumption that we're going to talk about this morning is the presumption of advancement. This arises where there's a specific relationship between the parties which would prevent a resulting trust from arise. It generally includes, or generally arises, where a husband or wife purchase assets together, but is ultimately registered only in one of their names. It also often happens where a parent might purchase something for a child. Equity assumes in those cases, because of the special relationship that's had between the two parties, that the benefit is provided by way of an advancement, or put more simply, a gift. Remember that, as the title suggests, each of these are just presumptions. That is, that if the court is ultimately satisfied that there is evidence that says, no, that's not really the way it should work, the court can look at that. But what we're talking about today is where there might not be that evidence, and how these particular issues can affect you in a very real sense. So I'm going to turn it over to our first speaker, Tom. Tom Carroll is a lawyer in our litigation and insolvency department. He's going to take you through a little bit more about the decision that we've referred to in the summary that we've sent around to you all today, and has also talked to you guys about the implications that this might have in relation to your family home by creditors who might come knocking on your door. Tom, I'll turn it over to you.
Hi, everyone. So yeah, like Paolo said, I'm going to be talking to you more about the commercial aspect of the decision in Bosanac, and how the boogeyman will maybe affect you. So one of the more interesting parts of the case was that what changed when talking about the presumption of advancement is what the court will take into account to actually rebut that presumption. So what it is that they'll accept as evidence that, like Paolo suggested before, what will rebut the presumption. Pardon me, I've just lost my spot. Off to a really great start here. I obviously haven't done one of these before. Now, so that's what's changed. Phoebe and Jack are going to go on to explain how it's affected their family and succession law spaces. But the other angle to this, which I'm dealing with, is why it should be concerned of to any business owner that faces risk. So many small business owners obviously have to personally guarantee loans or commercial leases, for instance, that puts their own personal assets at risk. So before this decision was made, a common way of shielding at least the family home from that kind of risk would be when say for example the husband puts the title to the family home in the name of the wife. So that would be a way of saying, because of the way the presumption of advancement operates, the legal title and the beneficial title would stay with the wife, and creditors wouldn't be able to come after the husband for that particular asset, were it to be in the family name. Now, what actually happened in Bosanac was the Commissioner of Taxation argued that the court was obliged to take into consideration that at the time that the Bosanacs purchased the family home, the husband had no other properties, and that the liability that the husband took on for that home loan was extremely significant. Now, the full court, on appeal from a decision of the just a single judge in the federal court, held that the court is actually required to take into account that those aforementioned issues, and decided that the husband clearly intended to retain a 50% interest in that family home, and therefore the Commissioner of Taxation was able to access this asset in order to satisfy its claim against him. Now, the actual dispute between the Bosanacs and the Commissioner of Taxation spans years, and there's something like 9 or more cases that have gone all the way up to the High Court and down. It's a very long and storied dispute. This particular case only dealt with very specifically the issue of the presumption of advancement. Now, the curious thing about this, in our view anyway, is that it was the Commissioner of Taxation utilising this principle and not a trustee in bankruptcy like you might expect. And in our view, the Commissioner being successful in this case opens the door to any third-party creditor to satisfy debts out of that family home. So anyone with a judgment debt against you, for instance, could apply in either the county or the Supreme Courts for a warrant to force the sale of the family home, because they're now in a position to prove more easily that the husband has a beneficial interest in the home, even if it's actually been put in the wife's name. So if you're a risk-facing director or similar, you should probably be quite concerned by this development. Now, Phoebe is going to talk about a potential solution to this problem through the use of a family law instrument called a binding financial agreement. That's not without its own risks, but Phoebe will go into a bit more detail on that. So the takeaway in this space, at least, is that you should immediately seek advice on how you should be restructuring your risk to shield the family home. You also might want to consider engaging with your creditors at an earlier stage, as the consequences of delaying the inevitable, which is dealing with those creditors, may cause you to be in a position to lose your interest in your own home. So there's no immediate questions. I'll pass the baton on to Phoebe.
Just before you pass it on to Phoebe, thanks for that, Tom. Can I just remind people that there is a Q&A function at the top that I neglected to mention earlier. If people do have questions as we go through, please do feel free to use that. Otherwise, we will open this up at the end for questions. Just before I pass it on to Phoebe, thanks for that, Tom. I think, as Tom says, the main takeaway is that this decision really has expanded the potential reach of third-party creditors, which isn't limited to the ATO. It's limited, it could be any particular creditor, not just your trustee in bankruptcy, that might use these arguments to try and get the family home, which traditionally might have been quarantined. Interestingly, there's probably also scope for liquidators to recover amounts from company directors using the same thought process. If they establish that a director has, for example, traded whilst insolvent, and that there's a debt owing to the company, perhaps they too are going to start looking towards proceeding against the family home directly, rather than going down the bankruptcy path, which can be quite costly and can take quite some time. So it's interesting to see how this might play out. Our next speaker, though, is Phoebe, who's going to look at this from a different perspective. So at the moment, we've got a decision here that really looks at commercial debts and the way in which creditors, including the tax office, are able to use these principles at law to get their money back. Phoebe practices in all areas of family law, including parenting and property, has had experience in cases involving trustees in bankruptcy in the family law courts, as well as just complex property cases involving trusts and companies. And she's going to look at the way in which these principles interact in her jurisdiction, and perhaps some of the ways that parties might be able to protect themselves prior to the creditors coming knocking. I'll turn it over to Phoebe.
Thanks, Paolo and Tom. So as Paolo said, I'm a lawyer in our family law team, and I'm going to take you through today how this matter of the Commissioner of Taxation in Bosanac impacts the family law sphere. So as we have heard from Tom and Paolo, this concept of a resulting trust becomes relevant in a wide variety of circumstances. And as you heard from Tom, it's relevant in the commercial space. And as you will hear from Jack, it's also relevant in the wills and estate space. But it's also incredibly relevant in family law matters. And as Paolo explained to you, this idea of a resulting trust is established when couples are often looking to protect their family home from business risks such as bankruptcy. And they place their family home in the name of one spouse. And it's usually the spouse who isn't at risk of that bankruptcy. As is very common in law, there is always an exception to these sorts of concepts. And with the resulting trust, the exception is a presumption of advancement. And again, as Paolo explained, this presumption of advancement exists when a husband purchases a property in the name of the wife. It will be assumed that the benefit, so the property, was provided to the wife by way of advancement, or in layman terms, as a gift. And the reason this is assumed is because of the very nature of the relationship that exists between the husband and the wife. Now, somewhat controversially, under Australian law, this presumption of advancement only applies in circumstances where the husband purchases an asset, which is then solely held in the name of the wife. The presumption of advancement excludes other relationships in the family law area, including where a wife buys a property that is held by her husband, in same-sex marriages, and in de facto relationships. And that becomes quite important when I come to my bit about how we can protect your property through a BFA, because BFAs do apply for same-sex marriages and they do apply in de facto relationships. Now, as Paolo and Tom touched on, this presumption of advancement can be rebutted, and it can be rebutted by having this evidence of actual intention of the purchaser at the time of purchase. And that leads us to this case of Bosanac. Now, in this matter, as you're probably aware, the wife and the husband equally contributed towards the purchase price of the former matrimonial home. However, the wife was listed as the sole registered proprietor. The Commissioner of Taxation was involved in this matter as they were trying to recoup a debt owed by the husband to the ATO. And I believe the debt was in about the realm of $9 million, so it was quite a significant debt. So the Commissioner was trying to submit that the wife held 50% of the beneficial interest in the home on trust for the husband, and that the husband intended to gain a beneficial interest in the property at the time of the purchase. The wife, on the other hand, argued that this presumption of advancement applied, meaning that the husband had gifted her the home and therefore the ATO could not use the value of the property to recoup the debt. As you're aware, on appeal, the court determined that the husband did intend to retain this benefit, and so ultimately this presumption of advancement was rebutted. And now I know that there's been a question about would it be different if the title was clear at the time of transfer, i.e. if the husband had not taken on a mortgage. And that's quite a relevant question when you look at what the court actually determined. And when they looked at this intention of the husband, they looked to things such as the nature of the transaction. So the husband had incurred quite a substantial liability under the loan agreement of the property at the time of purchase. They also looked to the contribution to purchase price. So the deposit and the mortgage repayments were both paid from a joint account, which the husband and wife had contributed to throughout their relationship. The court also looked at the purpose of the purchase. So the parties had purchased the properties to be used as their matrimonial home. And then finally, they looked at subsequent events following the purchase. So following the purchase, the husband used the matrimonial home to secure further borrowings in the sum of approximately $3.5 million to pursue a share trading investment. So the court therefore found that the parties had actually intended for the home to be available for the both of them to serve as further benefits throughout the relationship. So what does this mean in the family law context, and how can you then protect your home and your interests in other assets moving forwards? So prior to this case, couples could obviously rely on this presumption of advancement as a means to protect their assets, particularly from creditors in the event of bankruptcy, as we've just heard from Tom. So now that we've had this case, it's really important that couples seek additional protections to protect their assets. And from a family law perspective, this can be done by way of a binding financial agreement or a BFA, and it's often colloquially known as a prenup. Now, for those who don't know much about a BFA, it's essentially an agreement between a couple, including same-sex and including de facto partners, which formalizes how a couple's assets and liabilities and super will be divided in the event of a separation. By having a BFA, you're essentially contracting out of the family law court's jurisdiction, and they are a much more cost-effective way to protect your assets that you've worked hard to earn over the course of your relationship. And it can also protect your future income and any inheritances that you might have. Now, even though they're often referred to as prenups or prenuptials, couples can enter into these BFAs at any stage of their relationships, including prior to marriage or entering into a de facto relationship, during a marriage or a de facto relationship, during a separation but prior to filing a divorce, or after a divorce or the breakdown of a de facto relationship. If a BFA has been drafted properly and in accordance with the Family Law Act, they are legally binding and they are enforceable. So in the context of this recent case, BFAs can really mitigate that future risk as they set out the interests of each party and what the couples intend to have or what their interests in the assets were at the time of drafting. So perhaps in this matter that's recently been handed down, if the husband and the wife had entered into a BFA prior to the purchase of their property or shortly thereafter, they may have been able to use this BFA as a way to show that the husband didn't intend to retain an interest in the property, and therefore they may have been able to defeat the commissioner's rebuttal argument. So I think it's really important if you're at any stage in your relationship, but particularly prior to entering into a relationship, it's important to have a discussion with one of our family lawyers about potentially setting up a BFA, because it really is a way to protect your assets moving forward.
Thanks for that, Phoebe. Just touching on that last point, I think it probably is important to also remember that on appeal, the full court overturned the decision which had been made by the first judge. So the fact that 3 judges have intervened and said, no, we don't agree with how the first judge approached this, in circumstances where that first judge said the presumption of advancement had arisen and had not been rebutted, goes to show just how important it is that at early stages and before these issues arise, people really do need to start considering their options and whether or not there are things such as a financial agreement that they should be exploring. The other thing, of course, is that's very interesting that you touched on, Phoebe, was that these principles don't yet apply to de facto or same-sex couples. And so there's a disparity as to how the law looks at a married couple and a de facto couple. And even in one of the High Court decisions that dealt with this issue, that court said that it was not altogether satisfactory that there was this disparity. So it does highlight just how, even though people might be technically in the same circumstances, i.e. in a relationship and doing these things, you really do need to get into the nitty-gritties of what can we do to look after the family home? What can we do to protect that asset? Our final speaker this morning, before we move to some questions and a bit of a discussion, is Jack Conway. Jack's an associate in our Wills and Estates department. And though few of us, I'm sure, enjoy considering death, Jack will have a chat to us about the implications that these presumptions have at an estate level, and how these sorts of issues should be considered in proper succession planning. So I'll turn it over to Jack.
Thanks, Paolo. Hi, everybody. Yeah, as Paolo said, I'm a lawyer that deals with wills and estates. So I get to talk about death a lot and have the privilege of talking to everybody here about it. Death is probably one of the major trigger points that people often consider in their estate planning or when considering asset protection. People, for instance, who own assets, who might have entered into arrangements with the family home, like the husband and wife in the Bosanac case, they might be happy with the state of affairs and thinking that, oh, well, my husband and wife, my wife or my husband and I get along. We've entered into this arrangement. Nobody else should be interested in that. But when events like death or a family law breakup or bankruptcy, or even just a suit by a creditor come along, these can be trigger points that really cause other interests to come into play and might disturb the arrangements that a husband and wife have in place. The other probably very interesting thing about what might happen when somebody passes away in an arrangement where there's a potential dispute over the family home is just a matter of the evidence that can be found. Now, resulting trusts generally arise where there isn't enough evidence for the court to make a decision. And it's the evidence of the person who's contributed or who might have the resulting trust that's the relevant evidence that needs to be considered. Now, if that person's passed away, then there might be difficulty that might not arise in some of these other circumstances, just showing the court exactly what was intended and letting that proof come forward. But let's talk just briefly about what happens when a person dies, particularly with their assets. Ultimately, if somebody owns assets in their personal name, those assets form part of their estate. There's a legal process that generally has to be followed to deal with any assets that are in somebody's personal estate. Somebody becomes appointed as an executor or an administrator of that estate. They're responsible for dealing with the assets. Primarily, their first job is to pay creditors and make sure that all debts are satisfied. Until they've done that, they can't really do anything to deal with beneficiaries distributing the estate or that sort of thing. The first priority is to make sure that debts are paid. And where a person dies having creditors or where there might be claims made against that person's estate, it's only the assets that actually are in the estate that tend to be at risk. So if a person dies with nothing in their own name, then probably no creditors or persons who might be wanting to get a piece of the estate by contesting or bringing legal proceedings have much of a go. But if we think about a situation where there's a husband and the wife has a property in her name, which the husband has contributed to, as we can see from this case, it might be that the husband does have a residual interest or resulting interest which might form part of his estate. So briefly talking about some other circumstances. So it's important to distinguish assets that are in the estate from other kinds of assets. So somebody might own property jointly with another person. And when they pass away, the title to that property or the title to that asset will pass strictly over to the survivor. So jointly held assets don't come into the estate. They generally aren't assets that can be attacked unless there is some residual interest, like a resulting trust or constructive trust that can be enforced in some other way. Also, there are assets which tend to not be joint assets, but also fall outside the estate. A lot of people have superannuation, interest in family trusts, or life insurance policies. Usually these don't come into the estate. So legitimate ways to try and protect your estate, if you think there might be claims made against it, are to make sure that there's very little assets that are held by you personally, and that any assets are held jointly with another person or are in one of these vehicles like superannuation or family trusts, where they can't be directly attacked by any creditors or anybody wanting to make a claim. So obviously from the other view, if you are a creditor or if you are someone who's going to contest an estate, it's in your interest to make sure that there's as much assets as possible that are in the estate. Now, the other interesting issue is that an executor will normally have a duty to maximize the value of a person's estate. Now, an executor is normally going to be a close family member, and in the case of a husband and wife, it might well be the surviving spouse, and that might be the person who has an interest in this property that's got a question about whether there's a resulting trust in place or not. Now, the executor might find themselves in a bit of a conflict of interest because obviously, if we take, for instance, the husband and wife in this Bosanac case, let's say the husband had passed away, the wife is the sole registered owner of the property, but there's potentially this resulting trust that comes back to the husband if husband's passed away, and his will appoints his wife as executor. All of a sudden she's got conflicting interests. Does she investigate and pursue this resulting trust in her capacity as executor to try and enlarge what comes into the estate? She might have a duty to do so, and if there are creditors like the taxman who are trying to recover some debts, then they're going to want to make sure that the estate is being administered firstly for the benefit of the creditors, and then that anything that's left is dealt with as part of the estate. So similarly to where the Commissioner of Taxation in the Bosanac case was successful in coming in from the outside and asserting a resulting trust that the husband held so they could attack that or go after that asset to recover their debt. A similar thing could happen if Mr. Bosanac had passed away, and creditors could force or require at least the executor of the will to make sure that a resulting trust is recognised and constitutes part of the estate. Now, on one hand, if there aren't these issues about creditors or about somebody who might be challenging the estate, and the wife is the sole beneficiary and sole executor, then there's probably not going to be an issue, and you normally wouldn't have to investigate whether a resulting trust arises, because after you pay whatever bills there are, everything's going to go to the wife anyway. She would be able to consent or disregard any conflict of interest that arises because she would be getting everything. A different case might arise simply if there are some children who are going to benefit under the will. So if, for instance, the Bosanacs were a second marriage and the husband had children from a prior relationship, he's thought, well, my wife has the family home in her name, I'll leave what's in my will to my kids, then he might not have recognized that this resulting trust would arise, and the children might be thinking, well, we think that Dad had an interest in the family home, and that should be recognized, and that should be pursued and paid out. So again, if the wife is the executor, she's got a difficult position in that she might have to act against her own interests, put the interests of the estate above her own, in going after her own interest in the property, essentially. That will fall for the estate. Now, for a executor who's acting in conflict, there are some risks that can arise. Essentially, if beneficiaries or outside creditors think that the executor is not doing their job, they can be removed. They can be subject to legal proceedings and possibly made to pay costs. And if they breach fiduciary duties, then they can be liable to compensate the estate. So what can be done to help that? Well, prevention is better than the cure. So documenting intentions, getting legal advice at the time of the purchase is really important, because it's at the time that a property is purchased that the resulting trust and the proportions that it contributed are really solidified. So if you haven't considered this or thought about this at the time of the purchase, it could be too late to dispel the resulting trust issue. The other thing is that the will can specifically deal with some of the issues that might arise. So you can include a clause in the will that relieves a wife from having a conflict of interest in certain circumstances. And you can also try and provide in the will that if there is a resulting trust, that you make sure that whatever interest the deceased has goes to the right person. So if there is, or if there are multiple beneficiaries, wife and kids, for instance, you make sure that any interest in the property is specifically passed on to the wife. There are some other instances in deceased estates where this can come up, but I won't go too deep into it. So I think I'm running over my allotment a little bit. But a lot of parents these days are providing money for their children to purchase property. Again, a resulting trust can certainly arise in these circumstances. Now, Phoebe and Tom have both mentioned the presumption of advancement, and it's quite likely that a parent providing for their children to purchase a house would likely have the presumption of advancement applied, meaning that that would cancel out any resulting trust that would be seen as a gift to the child. But as we've seen in the Bosanac case, sometimes the presumption of advancement is not found, even in a case where it normally would. If the circumstances aren't clear that it will be a gift, then you could potentially find yourself in some trouble about that. And certainly the presumption of advancement applies from a parent to a child. It wouldn't apply, for instance, from a grandparent to a grandchild, aunt to a niece or nephew, or some of these other family relationships where there might be some assistance with buying the first home. Look, I might leave it there for now and send it back to Paolo, and I'll be around for some questions.
Thanks for that, Jack. So I guess as you've highlighted, Jack, again, these are issues that are best dealt with during a person's lifetime rather than potentially experiencing a lot of the fallout that can take place on the other side of it. And I guess what you've done is really highlight that succession planning is an important but often unthought of issue, particularly when people are looking at potentially getting some asset protection advice or considering structuring advice or looking at tax effective advice and the like. Often people just don't turn their minds to succession planning, which probably should be done at the same time. So I think if we take away one thing from today's discussion, I hope this really highlights the fact that even though sometimes these areas of the law can appear to be quite standalone, for example, these issues often arise in insolvency matters for trustees in bankruptcy and the like, it really is a case that it's all interconnected, and the same principles can affect three, on their face of it, very different areas of the law, but that if appropriate thought and consideration is given to these issues early on, particularly if you are looking to buy a house, or you are looking to structure yourself, or you are looking to purchase a new asset, thinking about things from an insolvency or a commercial perspective, looking at it from the position of what business assets do you own, looking at it from potentially a family law perspective, looking at it from a succession perspective is really important. And a firm like ours, of course, given that we do have the expertise in each of these areas, we're always happy to assist in these sometimes very complicated aspects. I'll throw it over to some questions now, because there's a few that's come in, and just Tom, Phoebe and Jack, if you can unmute yourselves, or make sure you unmute yourselves as well. I might just go back to you, Jack, because you touched on this. There's a question here. Would it be different if title was clear at the time of transfer, i.e. husband had not taken on the mortgage liability? I think you sort of touched on that in terms of the proportions in your talk. Could you maybe talk a little bit more about that?
Yeah, so essentially when a resulting trust arises, it arises because the title is registered in one person's name or in equal shares between two people maybe, but that doesn't reflect the financial contributions that were made. The interesting thing in the Bosanac case, and it was applying previous decisions, is that if there is a mortgage, then and that mortgage is joint between two people, if the property is registered in one person's name, the proportions will be worked out by who contributed to the deposit, and then what proportion of the mortgage each party was liable for. So in this instance, Mr. and Mrs. Bosanac both put in 50% of the deposit, and they both took a loan in joint names. And so they essentially said the interest was 50-50. If the contributions are different, then potentially a different proportion would arise and be reflected in the resulting trust. So it really depends on who's actually contributed to purchasing the property and in what proportions. And obviously if there's a reason to rebut the resulting trust, or the presumption of advancement might apply, then it wouldn't be, that wouldn't be the consideration necessary. But certainly if the resulting trust arises where there's a mortgage, it's the proportions of the mortgage that work out what the segments or what the interests in the property are for each of the parties.
Thanks for that, Jack. Tom, there's a question here for you. What happens if both husband and wife are directors in different businesses? Is there another legal mechanism that can protect our home and other assets from creditors?
So the answer to that's going to make every lawyer in the room collectively roll their eyes, and it depends. Yes, everyone's circumstances are different. So it's actually a fairly complicated question. There are ways that you can protect your assets from creditors, but that's going to change. So if you're concerned about that, that's something you should definitely contact your lawyer about, or one of us.
I think that's right. And again, as today's talk has sort of shown, there are various factors that really need to be looked at, which arise in very different areas of the law. So unfortunately, as the case in Bosanac, that we've been talking about, shows, these things unfortunately are not straightforward and do really need to be looked at from everyone's perspective. Phoebe, there's one here from Matt Gallant that might be for both you and I. I understand a BFA is regarded as a transfer of an interest and can be challenged under Section 120, 121 of the Bankruptcy Act. So only a court order is the ultimate protection, ? That's an interesting question, because obviously family court orders do have a significant role to play in bankruptcy matters, and the court can exercise a jurisdiction under the Bankruptcy Act to deal with voidable transactions and the like. But recently, there's also been cases where the court has exercised its power under the Family Law Act to set aside orders on an application by a trustee. Phoebe, do you just maybe want to talk a little bit about how the court might set aside final orders or final consent orders in the family law jurisdiction?
Yeah, so I guess with this question, maybe I'll first touch on your bit about the BFA. The BFA wouldn't necessarily be sort of dismissed if it was drafted at the time that you're purchasing the property. And at the time of when you're purchasing the property, as Jack has spoken about, it's the intention at the time of the purchase. And if you're putting that into a BFA at that time, it's unlikely that that could be used to defeat a creditor later in time if one party becomes bankrupt. If, however, you've got family court orders, a trustee in bankruptcy can intervene in proceedings. And if it's in circumstances where you've just recently transferred a property into your spouse's name just before you know you're about to become bankrupt, then they can intervene, and the court has a wide-reaching discretion to be able to reach into the matter and claw back a property. So you're right in that sense. And I think that is under Section 121 of the Bankruptcy Act, where they do have that power to bring that property back, so you don't defeat the creditor. But I think the point that we're trying to get across here is that, and as Jack said again, the prevention is better than the cure. So if we're dealing with these issues at the start of your relationship, and well before there's any scent of bankruptcy coming into your matter, that's at the point where we can really deal with these issues. And if the intention is documented, then I think it's better to be dealing with it at that point.
I expect Matt probably looking at this from a slightly different perspective, Phoebe, but no, thanks for that. But there is some recent case law. I think it's a matter called Hicks or something, which deals with setting aside consent orders made very, years and years ago in relation to trustees. So, Matt, if you're interested in having a chat about that, let me know. I think we have another question here. Is apportionment limited to 50% or otherwise the debtor's liability without infringing on the innocent spouse? Who wants to answer that? Tom, maybe?
Sure. Well, with that, it's just going to be, it'll be limited to whatever proportion the court finds that the innocent spouse holds in the property. So again, it's another it depends situation. Jack touched on it in his answer before when he was talking about the title question at the time, and how it's determined what proportion is owned by the contributions to the mortgage and the purchase price. So it's a very similar sort of calculation there.
We've got one from Stuart. Phoebe, this probably is for you. I gifted $1 million to my son 7 years ago. His property is now worth $4 million. Can my longer term de facto claim anything from my son if our union dissolves? It's probably actually both a question for you, Phoebe, and for you, Jack.
Jack, do you want to step in or?
Yeah, I can quickly deal with it. So again, I talked about everybody's talked about the presumption of advancement, but I talked about how it might apply to children. So a resulting trust, if it would normally arise, but the person that you've given the money to is somebody who you stand in a position of a parent of, so definitely to your child, the presumption of advancement would normally apply and would mean that there wouldn't be a resulting trust back. There might also be other issues with how you've structured the gift to him. A resulting trust generally only arises where the money has been directly utilised in the purchase of the property. Again, it's not something they'll be able to be given 100% answer without having full details of the facts and a full look at what's happened. But generally, in that circumstance, we would think the presumption of advancement would apply and that a resulting trust wouldn't arise back. So there wouldn't be an interest that you would hold in that property if that's the case. And Phoebe might just want to talk about what that means if the relationship breaks down.
I was about to say, Phoebe, that's a great answer that Jack's given in the context of how the law might look at things and how these presumptions apply. But we all know that the family law jurisdiction, judges there have very broad powers to deal with these things and look at these transactions in quite a lot of detail. Can you maybe talk a little bit about how, even though the presumption might apply that it's a gift, how the family court might deal with something like that, how it might investigate and explore an issue like that?
Yeah, it's a tricky one. So with the family court, when you're looking at gifts, if you have gifted it, it might be tricky for your de facto to claim anything if your relationship did break down. I mean, you'd have to be looking at the documents, as Jack said, that were drafted at the time to see whether it was a gift or whether it might have been said that it was a loan and that they could recall it. So all those sorts of issues would potentially arise with the family court.
Oh, sorry, thanks for that, Phoebe. There's another question here. Does this potentially affect who a party can recover against in insurance litigation or other civil negligence litigation? And I think Tom really touched on this before when he said this has really opened the window up to any creditor. Tom, do you maybe want to field that one?
Yeah, that's a pretty simple answer. So that's a yes. And any creditor that gets a judgment debt against you, we're of the view that does open the doors to take advantage of that. So it can affect, pretty much any third party that gets a judgment debt. So regardless of the kind of litigation that you've engaged in, it could be insurance or civil, that it opens the door to that asset being attacked.
Thanks, Tom. I think we've dealt with all of the questions. So just again, thank you to Tom, Phoebe and Jack for presenting today. I hope everyone has seen just how complicated some of these issues can be. And we do invite anyone who has specific questions, and some of you have asked some pretty targeted questions in the chat that are a bit difficult to answer here. Please do feel free to reach out to any of us and have a chat about these things. There are obviously many issues at play here, many things that you need to factor in and balance and decide ultimately which path is best for you. So thanks to everyone for attending this morning. This will be up on YouTube at some stage over the course of the next day or so. I think someone asked a question about that. It will definitely be up there and you will be able to access it. There'll also be a few short articles that go up on the website just touching on the issues that the speakers today have spoken about. There'll be another breakfast briefing presented by us in about a month's time or so. So please keep an eye out for that in your emails. And although that's likely to be another webinar, we are very, very hopeful that in the not too distant future, we'll be able to resume having these in the office and actually seeing you all face to face and being able to have a chat and a cup of coffee or tea. So once again, thank you to everyone for attending. Thanks, Tom, Phoebe and Jack for participating. And if anybody else would like to reach out and have a chat, given that we're not all wandering around our common area having that cup of tea or coffee, please feel free to give any of us a call for a chat. Thanks very much.